like from how old you have to be to run for Congress in the Senate, to the exact specified powers that they have and no more, because remember, only certain ones were seated. And they were very, very protected. That's why there was such rancorous debate at the Virginia Ratification Convention. Matter of fact, it was so rancorous, a lot of people don't know this, but Edmund Randolph and Patrick Henry, there was a duel challenge. I don't know which one did it first, but those guys, there almost was a duel between those two men. The debate was that heated, but cooler heads prevailed and they didn't go outside. But this is the legislative branch. This is the executive branch. Look at the real estate. Lawmaking body, executive head, judicial branch. Look how small it is. That's the real estate arm. And I'm going to show you basically the judicial branch in the federal Constitution is very small. It's very limited. But that's what, and then the rest of it right here, the relationship between the states and the process for making amendments. We'll be talking about Article 5 tonight. And then, of course, the signature block. 39 people signed the Constitution. I'm just going to do some highlights on the article, on Article 1, Article 2, Article 3. Things that I think that if I'm given only 45 minutes or 60 minutes, that I want you to take away from it. If you've never heard it before. If you've heard it before, then I hope it just reinforces it for you. The first principle of American government. Article 1, Section 1. It's the very first sentence under the preamble. If I had more time, I'd play you Barney Fife reciting the preamble, because it's one of my favorite Andy Griffith shows. Because he just, it's great. But right after the preamble is this first sentence, the very first sentence. It says, all legislative powers herein granted shall be vested in the Congress of the United States, which shall consist of the Senate and the House of Representatives. So we learned two things from that. We have a bicameral Congress, but there's one very important thing that we need to understand that is being flaunted today by the president and not being acted upon by the other branch that can stop it. And that is that only legislating power is granted in a Congress. No one else can make law. The executive branch cannot make law. The judicial branch cannot make law. Oh, well, Bob, the executive branch doesn't make law. They make regulations. Violate a regulation that the EPA writes. See what happens to you. Thousands of dollars in fines, years of imprisonment. Only the legislative branch. Why did the founders do that? They were brilliant men. They weren't infallible. They were fallen people just like me and you. They made mistakes too. But it was a brilliant document. And I believe because, again, my faith and my biblical worldview requires that I just see that he did that. But wherever you're coming from, the first principle of American government, only the Congress can make law. Only the Congress can make law. Real quick, I want to show you this. This is something that may be interesting to you that you didn't need to know. I'm skipping to Article 1, Section 8. If you were looking at the parchments, this would be the second parchment about halfway down. Halfway to 2/3 of the way down. There's this Article 1, Section 8, the enumerated powers. I want you to, if you look right here, you'll see that, look at where the lines start, the text starts. Oh, Bob, you're getting into the ink on the parchment. Yes, I am, because it's very instructive and important to see this. Look at the indentation right here. Matter of fact, I'm going to zoom it for you. If you walk up to the parchment at the National Archives, and you look at it, and you look at Article 1, Section 8, you're going to see an introductory paragraph, and then you're going to see 17 enumerated, that's the word that's used, enumerated, or listed powers. Okay? Matter of fact, the guy that actually put ink to animal skin was the guy by the name of Jacob Schallis. He's the guy that actually wrote them. There's a little fun fact for you. I'm convinced if Jacob Schallis had Microsoft Office, he would have put little bullets next to him, little dots. Because he indented them for a reason. Because they just decided to indent them. He didn't. Nothing is there by accident. He did it for a reason. And what I'm teaching you here right now basically is a little bit about original intent. In my constitutional law course, I teach how do we determine original intent. So you're getting a little bit of that right here. But here's Article 1, Section 8 without the Jacob Schallis where you can't read it. So here's the introductory clause. The Congress shall have power to lay and collect taxes, duties, imposts, excises, to pay the debts and provide for common defense. Why did they put this in here? Because under the Articles they had no power at all to do that. But they were also afraid of the power of taxation. They were getting I was going to use the term raped by the British. Okay? Of taxation. They were fearful of that. So what they did was, okay, we're going to give a power of taxation to the federal government, but we're going to tell them what they can only tax on. That's it. They're going to list the certain things. That's it. No more. Everything else is up to the states to do that. So look what I've got highlighted. To provide for the common defense and the general welfare of the United States. This is important for my Convention of States discussion, to you to understand this. This is one of the two most perverted pieces of text on this parchment. Okay? Those words, the general welfare of the United States, that has become today, it has been twisted and stretched over the years, and it doesn't happen all at once. Remember, you've got to be vigilant, because little by little, the progressives, the liberals, don't call them progressives, call them what they are, liberals. They have little by little, they have twisted and stretched this Constitution. They didn't do it out overnight, but we were asleep. Constitutionalists were asleep. Today is used to legislate. Well, Bob, how do they legislate all that stuff that's not listed here, right there? The courts have interpreted that to mean anything. But we know what they meant by it. We can know what they meant. Well, how do you know? Well, it's just your opinion. No. None of this stuff is my opinion. We can determine original intent. We have source documents. We have the Federalist Papers, 85 of them, explicitly explaining everything in the Constitution. We have the notes from the Convention of 1787. If you go online tonight or some other time and Google Madison's Notes of the Federal Convention, anything of that close with those words, and you will get several very good sites that will have calendars on them. And the convention, the Federal Convention, how many of you have heard, I'll just say this tonight, how many of you have heard the term con-con? Con-con. How many of you have heard the term con-con? I'm here to talk about the Convention of States tonight, and there's some people that are using the term con-con. You know, you can use whatever terminology you want. When you leave here tonight, if you want to be considered a constitutionalist, get rid of that term. Because I will ask you, but I don't want you to answer, because I won't put anybody on the stop. My goal tonight isn't to embarrass anybody. You guys haven't taken the time to study this. That's not your thing. That's my thing. So I'm not here to embarrass you, to belittle you in any way. I want to teach you tonight. Okay? If we're going to be constitutionalists, we need to be faithful to history and faithful to the facts. Okay? This convention that was held in 1787 was not the Constitutional Convention. If you were to go back in a time machine, and I'm a geek on the colonial era. I love the colonial period and the Revolutionary War period. If there was a time machine, I'd go back as long as I could take my AR-15. But if you were to go back, nobody at that convention called it the Constitutional Convention. It was called three things. It was called the Federal Convention of 1787, it was called the Philadelphia Convention, and it was referred to as the Great Convention. It wasn't until about 50 to 60 years later that historians began to look back and go, as a short term, the Constitutional Convention. And that's okay to call it that if you're calling it for that reason. Today, it's used to disparage the idea of Article 5. And I'm going to show that to you in a moment. But that term con-con is used today by those that oppose the Article 5, that to be honest with you, either number one, they're ignorant of history, or number two, they're intentionally distorting it. And I'll let those people make the choice. I'm not trying to be mean, I'm not trying to be harsh, but I've come to that conclusion that that's got to be the case. Because when you look at history and you look at the facts, you see the truth. But back to this issue right here. The General Welfare Clause, one of the most abused portions of text. So Bob, what's this? Why are you showing us the indention? Because Madison says in Federalist 41, well, Bob, how do you know what they meant? Isn't it just up to your interpretation like the courts do today? No, it's not. These words have meaning. If you wrote a letter today and you sealed it and you said, I want my children, my grandchildren to read this letter. Let's say, Kathy, you write a letter and you don't want it to be opened until your great-grandchild reads it 30, 50 years from now. When they open that letter, do you want them to read what they think you meant or what you meant? What you meant when you wrote it. You would be pretty upset if they took the attitude that I'm just going to read whatever I want it to mean in this letter. Not what you meant. Now, the founders told us the same thing. I'll show you a couple of quotes in a little while where they told us, if you want to know what we mean, Jefferson said, carry yourself back to the day that it was written and look at the intent. So we can go to the ratification conventions, we can go to the 85 Federalist Papers, I can take you to the notes. And I was telling you about Madison took copious notes every day of the convention. You go click on them online and see the notes that were taken every day. We know what they meant. Madison, and specifically in Federalist 41, there were some people that were worried about this language. Even in that day, they were worried that that language was broad and that it might be abused. Those people today, I'd have to look back and say, they were right. But they were only right because we are an unenlightened people. Because if we're enlightened, we look and say, what did they mean by this? Madison says, this can't be a blank check to mean anything because it introduces the enumerated powers. The general welfare applies only to the enumerated powers. In other words, these things that are going to tax and spend on have to be general in nature. Today, the courts, because of years, it didn't happen last night, because of years of twisting, I would submit to you decades, 80 to 100 years, the courts have twisted the meaning. This is the second most abused portion of text, the Commerce Clause. But there's a reason why it's indented. That's an introductory clause. But I don't want to linger on that. That's for a much deeper discussion. Let's just jump to the executive branch real quick. The executive branch right here. Just quick, just to show you a couple of things. And this really ties into the first part. How do we get justices on the Supreme Court that don't care about original intent? It should be the very first and most important litmus test for any judge on the federal judiciary. And there's 9 members on the Supreme Court. Mind you, there's another 870 some in the federal judiciary. There's almost 900 judges, and every single one of them gets appointed by the president. And every single one of them has to be agreed upon by the United States Senate. Hear me clearly on that. The primary test for a Supreme Court justice or any federal judge needs to be, do you hold to original intent? And it shouldn't be just a yes answer. It should be, let me look at your history and see if you've done that. Let me see what you've written. When you look at the justices on our Supreme Court right now, there's 2 of them in particular. I think 3, but I know 2 for sure, 2 of them. Justice Antonin Scalia and Justice Clarence Thomas. Every time they write a decision, because I teach these decisions, we dissect their rulings. When you look at their rulings, they're laced. They're filled with the founders' quotes. They're filled with everything from the founding era. They're filled with the Federalist Papers. They're filled with the notes from the convention to explain why they're ruling a certain way on constitutionality. When you look at Justice Ginsburg, Justice Breyer, Justice Sotomayor, Justice Kagan, thank you, Senator Graham, for Justice Kagan and Justice Sotomayor. Sorry if I'm offending you if you're a Graham supporter here tonight, but I'm just going to tell you the facts. You can let them fall where they may. But those, they tell us. It's not like I'm pointing the finger and accusing them of not following original intent. I don't have to accuse them. They tell us that. Justice Ginsburg stands up and says she doesn't believe in original intent. They tell us that. We don't have to wonder about that. So how can someone like that go on a court? They have to be faithful to that document or they're going to get it wrong. This isn't just an idea. They're going to get it wrong if they're not faithful to the document. And even when you're faithful to the document, good people can disagree. Every once in a while, Thomas and Scalia will come down differently, but it's rare. But both of those guys are striving for original intent, or what I call fidelity, faithfulness to the United States Constitution. But look at the job of the president with the advice and consent of the Senate. Senator Graham, again, I'm sorry if you're a Graham supporter, I'm offending you. I'm just giving you the truth. I'm not trying to beat up on him. He started out as a very conservative guy. For the last 2 Supreme Court appointees, Justice Sotomayor and Justice Kagan, twice, not once, but twice, and it's not just him, there's others, but he's my senator, so I've got to use him as an example. He stood up and he said, elections have consequences. What he meant by that was, hey, the president gets to pick them, and it's his choice. And he goes, when we have a Republican president, we want to get our picks too. That's not the job. The founders intended for this is what's called a check in the Constitution, by the way. You've heard of checks and balances? A check is a pushback. It's really a body slam. It's a way to push back against the other branch. The founders, that's why they created the brilliance of 3 branches, was to keep this balance. You know, people say today, oh, there's too much obstructionism in Washington. Do you realize that the founders intended for there to be obstructionism? They did. When you look at separation of powers, they intended for it to be extremely hard to pass a law because of that whole idea about liberty and order. They understood it. They made it very hard to pass a law, or at least it's supposed to be. So they said, listen, this isn't just, okay, the president picks them and I can't find any criminal background, so boom, they're on. Because I want our guys when we have a Republican president. There's supposed to be a pushback. That's egregious. Think about this for a moment. Those 2 justices will be on there how long? Till they stop breathing. Exactly. They're going to be there. Or they quit, which is extremely rare.
They might stay afterwards. Ginsburg looks like she's already...
Well, Justice Sandra Day O'Connor. And she's done some good things. Beat up on her. She was appointed by a Republican president, but she got very liberal in her old age. I'm never going to have that. If I ever get liberal in my old age, you have permission to come shoot me. You can't say that because people get older, they get more liberal. But, she still actually gets to go and get on court because she's for life. Even though she's not on the Supreme Court anymore. I heard a couple months ago she was taking a place on one of the circuits, the 4th Circuit, I think. Yeah, it's extremely egregious when a senator has a lackadaisical attitude about that. I would submit to you that one of the greatest powers that a president of the United States has, people say, Commander-in-Chief, go to war. Those are huge powers. They involve the life and deaths of our treasure, our nation's treasure. But I would submit to you that the greatest power the president has is to appoint justices to the federal courts. Because when a Supreme Court justice makes a ruling, it's done. It's done. It's absolutely finished. Fini. Roe versus Wade. It's done. Absolutely horrendous. And you and I can't do anything about it. There are ways, but it's almost impossible. So he gets to appoint justice in the Supreme Court. I can't linger too much longer. They keep moving here. He shall take care that the laws be faithfully executed. This is the first time in history. I'm sure there have been other presidents that have done this, because he's not the first guy. This is the first time I know, and I'm a political geek like you guys are, I watch this stuff, that I've ever seen a president walk up to a microphone and openly state that he was going to disregard the immigration laws. Just say law. It doesn't matter which law, but that was the one. We've known they've done it before under prosecutorial discretion and all that. I've never heard one stand up and say, we're not going to do it. It's almost a challenge. Then he goes into the well of the Congress for the State of the Union and he tells them, if you don't act, I'm going to use my pen. Anybody see Trey Gowdy ranting on the... It was good. I have one problem with that. I love Trey. I love his rants. They pump me up. They get me all excited. But I got to be honest with you. We got to be able to point at our own and say, listen, we can't just point at the libs. I'm starting to get a little irritated because a lot of it's just rants. When the laws aren't faithfully executed, that's an impeachable offense. This is a target-rich environment, and I told someone last night that if you name me a cabinet member, and I think I can produce an article of impeachment on that cabinet member. Maybe there's a few I couldn't. Holder's at the top of the list. Okay? That is a check. The founders put that in there as one of the things. So the Congress has come up with a law. I'm not trying to beat up on Trey. I don't like Trey. He's a great guy. But he did it, so I got to use him as an example. They wrote a law, and he was talking about it from the floor the other day. Now, listen to this for a minute. The law is to enforce, it's the Law Enforcement Act. So we're going to write a law to tell the president to enforce the law.
Which he's going to veto.
He's supposed to do that anyway. You don't need a law. You have the highest law in the land that says that. But I understand it. I know judicially, I know what he's doing. He's trying to get standing to go into court. And that's good. That's okay. It's like Tom Rice has got the Stop Act on the thing that he's doing. I get all that. But here's my problem with that. All those things are extra constitutional. They're all outside the Constitution. They can do them, but they have things that the founders gave them. Impeachment is a founder-given. People say, well, they're not going to impeach him, so that's a waste of time. No, you don't understand. Again, be a constitutionalist. The House of Representatives' job is to impeach. You know, there should be tunnel vision on the House and tunnel vision on the Senate, except when they have to reconcile bills. In other words, the House's job is to indict the president. That's called an article of impeachment. They send it over to the Senate. The Senate's job is tunnel vision to look at the indictment and conduct the trial. You realize that the House of Representatives would bring an indictment. It's the Senate. It's not like Harry Reid's not going to do it. They're bound to hold a trial. Now, we know they won't convict him, but how can we ever get to a trial if the House members don't do their job? I'm just asking. How can we get their job is to do it? I've heard this. I've had congressmen tell me this. They're not going to do it. They're not going to try. But that's not your worry. Before I can put pressure on them, I need the article of impeachment so I can rally the troops and start hammering the Senate. Well, we can't hammer the Senate until you do your job and indict.
Tom,
Yes, ma'am.
could I ask you, okay, if the House brought it, if they tried to impeach, all right, and let's say they say, yeah, we're going to.
Yes.
It passes. It has to go to the Senate.
And it has to have it
And
there.
as long as Harry Reid is head of the Senate,
He's gonna say he doesn't have
how would
choice.
it ever?
He has to conduct a trial. We know they won't convict, but he's mandated to conduct a trial.
Assuming someone appreciates the
Supreme Court justice will be the Chief Justice of the Supreme Court will be the Chief Judge will be the judge on the court, but he is mandated to have a trial. He will do the trial. They won't convict. We know they won't convict.
So our stumbling block right now is not the Senate.
That's correct.
See, that I was told.
That's correct. No, they tell you that. No. We were told that because they tell us that. They like to say the Senate won't do it. John Boehner is infamous for this. We can't waste our time because the Senate won't do it. Your job is to have tunnel vision on your functions. In Article 1, it says, these are your things to do. When you see unfaithfulness in the other branch, your job is to bring an indictment. Period. That's their job. I know, you can go through semantics about, well, it was a waste of time. If we're constitutionalists, we've got to do what the Constitution says. We got to always have to stand on the Constitution, because when you drift from it, well, in this one instance, we're going to go over here because it won't work. We're no better than the liberals when we do that. We're no better than them. The judicial branch, real quickly. Article 3 establishes the court, doesn't spell out a lot of specific duties for the court. One Supreme Court. Realize that the United States Constitution only specifies the Supreme Court. It says, and in such inferior courts as the Congress may from time to time ordain and establish. Well, what's the big deal? Move on. Very important for you to understand about the Article 3 branch. The only court that the Congress has very little to no power, they do have some power over it, is the Supreme Court. You realize that every other court, and let me just jump down here, just to let you have a visual. This is the federal judiciary today. The SCOTUS is the Supreme Court of the United States, 9 justices.